discussion and expression of opinion by IPs. All experienced IP should discuss, because if you observe in this, lot of comments has been given about IP action and also inaction, and especially the format importance and the kind of the non-compliance and its implications. In view of that, as an IP and with your experience, what you suggest where it should be and what process, because it was a process flow. So the process is mentioned and how it should be ensured, where give your views. And this will be the roundtable, and I will request each one of you to raise your hand so that one after the other we can start it, because there are so many people, it will be difficult. So if we can do it with the raising of hand, it will help us. So with this, I will open this forum for discussion. So Mr. Venkata has raised the hand first. Of course, on your system you raise the hand, but since your video is there, I can see. So you can start the please.
Thank you, ma'am.
Yeah, Mr. Venkata, you can unmute and speak.
No, I am thanking you. Thank you, ma'am.
Thank you. Okay, thanks. Okay, so in this scenario, if you see that after 4 years, I know this case law has affected so many people, and it has given a shock to the Indian corporate world, your legal field, and also insolvency professional, because it is everyone is concerned of taking back the decision and the entire process after 4 years. And the question on the legality of Contract Act in implications and the binding impact of Contract Act is also questioned now, that whether contract law will be, how it will be implicable. And as every IP here knows that it is so difficult to get the resolution plan and the investors in India to get the stress asset. Of course, when it is a asset heavy company, it is fine, but especially when it is not asset heavy, it becomes really difficult. In such a scenario, when you get the plan, you implement, and then the corporate are told that the plan is not accepted after 4 years, how it will impact the future invitation and investment in stress asset, and also what will be the impact on IBC. So I'll request if anyone wants, I'll suggest, since I'm telling that I have my views and everyone has that views, so we can start with Mr. Alhada. You are there. Can you start? Can we start with you, please? Your views on the subject and your suggestion. Hello. Friends, this is round table discussion. I'm not going to present it. I think the people has the myth that I am going to speak and say. I'm telling that it is a discussion. So that's why everyone is needed to contribute. I hope everyone has gone through the case. Hello.
Yes, madam. Actually, I have not so far handled any case. I'm a fresher in this IBC field, but I have gone through the case and I have attended some of the webinars conducted by our senior professionals, like Triple A and IPNet and all. So what I understood from this is that Supreme Court, after 4 years, I think they have rejected the resolution plan. And after implementing it and paying the amounts to the creditors and going back to the square one, it is almost a difficult one for the liquidator who has to commence the liquidation as per the court order. This is my understanding. And remaining the things, as the Supreme Court has pointed out, I think as regards to the illegality, definitely there are some illegal things that have happened, like 29A was not verified by the IP. He was not eligible to be the successful resolution applicant. Thus, JSW was not supposed to be a a resolution applicant. That is one thing. And there is inordinate delay in submitting the resolution plan to the NCLT after approval of the COC. All these things taken together, I think the Supreme Court has pointed out all the things properly. But the decision given by the Supreme Court, I think it needs I feel it needs a revision. Otherwise, taking it back totally to the square one and refunding the amount to the bankers and uh, and if the liquidator has to commence liquidation, what balance sheet basis that they have to after 3 years or 4 years, I think they have conducted a lot of operations and there is a lot of income also earned by the JSW. All these things will be a critical points to the liquidator, and where the IBC has not defined this kind of situation anywhere in the code. I feel this is my understanding as an infant in this thing.
So at least,
Certainly, it needs some kind of revision and some alternative implementing this. So, take care, this has happened. Unfortunately, this has happened, but maybe levying some penalty on the JSW or increasing the amount, or so that creditors will also be not, unhappy. I feel that. So,
yeah. And if you observe that the Supreme Court has rejected on the ground of section 32, that is section 30, subsection 2, and 31, the decision under section 31, subsection 2. So if 32 refers, its entire onus comes on resolution professional. So resolution professional shall examine each resolution plan received by him, confirm that, that 1, 2, 3, A, B, C, D requirement, and then you give the compliance certificate, and then the section 31(2) says that if that so court is not satisfied that it is complied with these conditions, then it may reject. And it has given. So I see that entire onus is on resolution professional is given in the judgment that this.
yeah, even the COC was also found fault with that.
Yeah,
Not
everything is there. COC and also they have taken the applicant also under JSW also they have taken it. Even the court judiciary also they have criticized. But fine, in the judgment they are telling that since the requirement is not there. So here a lot of onus is also given on the
insolvency.
resolution professional. In view of that, I will, request a view of our own members. Mr. Granthi, you are there? Mr. Granthi?
Yes, ma'am.
Can you start this discussion on your view on this in view of that, the judgment is specifically speaking on section 30, subsection 2 and section 31, subsection 2. Both refers to the duty of the first refers to the resolution professional duty of giving the checking and giving the report about the compliance of the resolution plan.
Okay, my submissions at this stage in a way are limited. I have not read the text in detail. I have only read various summaries, not just at one place. But there are two broad parts to the judgment. One is on the case itself and its outcome, and what are the basic grounds on which that decision came about. The second part is observations on various aspects through the 4-year journey and prior to that, which are equally important, though not, none of them, even if they were not there, the outcome may not have been probably different. Okay. So the outcome is basically, in my opinion, only on two things. First, that the 29A ineligibility having been there and having been suppressed, there could never have been a resolution plan which could have been even examined. So it was like an ab initio null and void. Okay. And 29A is not subject to discretion of anyone. Neither COC nor any of the tribunal or even Supreme Court. It's a matter of complete yes-no binary. Either you are eligible or you are not. If you are not, in certain cases, there are measures within the code itself of how to cure your defect and become eligible again, which in this case was not. Not only was, at this moment, I'm not saying too much about, the observations which relate to whether what RP should have done, not done. I will, irrespective of that, when it is there, so that is not there. The second and very fatal one, equally fatal, was that this was a unique case of a party challenging a judgment in its own favor simply because it wanted to delay the whole process, which was naturally the only reason would have been money, right? You don't have the money, you somehow find one excuse or the other. So a plan which is given by it to the COC, gets approved by the COC, it goes to the NCLT, gets approved by the NCLT, and the resolution applicant itself challenges the approval of the plan. Nothing can be more ridiculous than that, because that's a clear case of a fraud perpetrated on the justice system itself. So on both counts, this was something which was glaringly wrong. Of course, there will be people saying, it took 3 years, 4 years, etc. Well, in India, nothing happens before 3 to 4 years. Anyways, that is the whole system. I think all things considered, we are talking in the IP community from a very privileged position. Thousands of people are stuck in jail for periods which are longer than the maximum punishment that they are that can be given to them simply because they cannot pay the money for the bail. So compared to that, I think we are far, far better, and it's time that IPs stop trying too much about NCLT and all that. We should compare, and you will find that there is no forum. I can say this with confidence, no forum in this country, judicial or quasi-judicial, which is faster and more efficient than NCLT. So you're still the best. That doesn't mean we are the best in the world. Fine, but that's a long way. That is true for every aspect of life in this country. So I don't think we should spend too much time on, being like crybabies. So these are the two. Now coming to the aspect of what RP should have done or not. Now the extension part. Okay, that's a very important one. The question is, and probably this is what the observation is, that if when the plan was filed for approval of NCLT, if the period had already got, crossed the maximum allowed or approved at that time, it was mandatory to file along with an application for extension. And then after that, NCLT might take 1 year, 2 years for a variety of reasons, including multiple litigations that would have been pending before it. In this case, we knew that when the plan came up for approval before NCLT, the ED attachment was a big issue. Not only was it a large issue, it was also two arms of the government effectively fighting each other, where the finance ministry was saying that it is prospective and the corporate affairs ministry was saying it is retrospective. And, strangely, the cabinet minister is same in both cases.
Yeah, that's the concern.
So this is something which cannot be laid at the door of the RP. I mean, this is like a fight between the elephants. We are grass, we will only get trampled in it. But whatever the RP had to do or not do, like in any other case, there will be, even in here, we should, in my opinion, take all these observations as warning signals for us. Okay, going forward, ensure that these things you don't overlook, because not one of them is of a nature which is impossible to do.
Yeah.
I mean, it's something so simple. File an application for extension, enclose format along with your IE. Do we have to be told about it? Okay, just because NCLT overlooked it, NCLAT did not take cognizance of it, does not make something which is wrong right. Never does. Okay. At the end of the day, the judgment has, while it has made observations of the conduct of the RP in the case, I don't think it has recommended any punishment per se, or even, hinted towards that. Okay, that's something which IBBI may or probably will take cognizance of and do it. But the Supreme Court did not say so. So all in all, I would say that we should take it in the right spirit as to what is mentioned, and where things become difficult to do in a particular case, it might. Like the 29A example. Now, it is, I don't think any sane court or judge in the land will expect RP to be even more efficient than CBI and ED in an investigative manner. But once that somebody has brought it to your notice and then you don't do anything about it, that is not acceptable. And from what I can remember, I'm going by memory here, I'm not too sure, but this had come up during the process. That there is, because somebody will, bring it up. No, it had come up either at NCLAT level or somewhere that there was a related party issue and they had suppressed it. So at that point, at least, RP should have taken that and gone back to NCLT and saying, new information discovered. Now my application to approve this plan has got vitiated. Please give direction. The whole thing would have been different.
Right.
Okay. So
Right.
this is what are my observations.
Thanks, Mr. Gandhi. It can be said that what Mr. Gandhi has pointed is view that the process to be followed is very clear to be followed by RP. It's very crucial. And RP has to take all his efforts to comply with that because it has implications. And this case is the result, or it indicates that each process is crucial, it has its reason and it has its own implications if it is not followed. So we have to be very alert in complying with that to avoid this kind of consequences. Thanks, Mr. Gandhi. Mr. Anis has raised the hand. Mr. Anis, you can unmute and speak, please.
Yeah, my perspective is that, this was actually one of those dirty dozen cases. I think the IBC has evolved in terms of procedurally, in terms of it has actually codified a whole lot of things that the RP is required to do in respect of inviting resolution plans, evaluating resolution plans, etc. So, I mean, of course, those issues apart, in which particular to this, at least if the RP is at least following the code, there is little chance of him, falling foul. Of course, the 29A is again, is a worrisome thing and at one level. I mean, apart from the bid evaluation and the not declaring H1, H2, etc., that apart, how is the RP going to certify by somebody is 29A, irrespective of anything? I mean, it is speculation to a certain extent, Mr. Ganti, with due respect, by RP knew about it. But how can you hold RP saying that, if somebody is given affidavit, then, he's not eligible? In all situations, it may not be possible to say very confidently. So one has to, end the thing sometime. I mean, one has to end that issue sometime and, proceed forward. And it puts the RP under undue risk, actually. Somehow, that leaves a bit of a sour taste, in terms of, carrying forward a process. One more thing, as far as the whole thing, worrisome thing is that NCLAT is not authorized to adjudicate on the PMLA. I mean, this matter has arisen out of the code, and PMLA, if this RP is supposed to go to PMLA, he is supposed to go to NCLT, he is supposed to go to DRT. That becomes a big issue in terms of, to which is the right forum, and also in terms of, extra load that the process will be subject to. One has to be now careful in terms of which is the right jurisdiction where appeals need to be filed. So these 2 points I would like to, put for discussion. Yes, sir. Ganti garu.
Yeah, Mr. Gandhi.
Yes, I would just like to respond briefly on 2 points. PMLA. The point about PMLA was that NCLAT has no jurisdiction to set aside an attachment under PMLA, and that is absolutely right. And only to overcome all such type of things, 32A was introduced into the IBC. Now, 32A doesn't set aside attachments. It extinguishes the effect of such attachments on a resolution plan being approved or liquidation, and the party concerned, okay, the acquirer,
Yeah.
is or was never in the management and DA. So that's a twin condition, 29A plus not being in management. Now, not being in management also includes all those MSME parties where if they are hit by such a thing, they do not get the benefit of 32A. Okay, so there is a provision in the code which is Ganga Snan, effectively for the acquirer, but it has to be, jo jisne paap nahi kiya ho pehle. Okay. For such people, 32 applies. Attachments are not set aside. They are extinguished by operation of law. Two totally different things. Okay. So nothing wrong in this judgment if it is understood properly. What they should have. I mean, I used to find it very funny when I was reading all those fights between the two. Okay, there was 32A mentioned, and ED had taken the plea that it is retrospective. No, sorry, prospective, not retrospective. And that is obviously a decision which the higher courts have to determine. RP is nothing to do with it. He has no role. Neither NCLAT, even NCLAT cannot. It's a constitutional matter. As to is it prospective or retrospective, High Court, Supreme Court, at that level it would have had to be dealt with and should have been. The Supreme Court judgment was harsh on NCLAT, which ordered that the attachment is set aside. And they said, no, that you don't have. That is right. But if they had gone back, because 32A actually came later, and that's why all this controversy. Okay. So if they had gone back to NCLT and said that, now give us this, because 32A, by its very wording, actually speaking, is about being retrospective because it is talking of past sense, not future. The provision itself, it doesn't have to say it is retrospective, is meant to be retrospective. They could have gone that. So these are, of course, legal technicalities as to which road you take, because depending on the road, the destination changes in law. We know that, okay? And that's why we say, no, you take this counsel because he will be better, and that counsel and all that. Why? Because that also matters. Okay. Now, about knowing or not knowing about 29A, what I said was, if you know, you have to inform, but you are not expected to be an investigating agency, and nobody will hang you for that. Because the code and the regulations are very clear. They do not expect RP to do anything. The wording is very clear in the regulation. Based on the material on record, not create a record, but what is available on record. But the primary document, and which is now, more emphasized in the new liquidation regulation, where they say your declaration is all that is there. The provisions which related to 29A investigation have actually been dropped in liquidation. So IBB is very clear on it that you can't be an investigator, but you have to ask the question when you have a doubt.
Actually, just on this point, later, I mean, this trend has now picked up. Said there is a 29A study itself being commissioned. There are these agencies have cropped up. So, it is safer for the RP now. And you have this report. So
Good
in
business.
the 18,
More than anything, it is
absolutely.
wisdom.
No, but at least it gives a structure, and everybody is now the safe in a sense. By adequate diligence has been done.
But when it is, Mr. Anis, when the stake is very high and it is involving
Yes.
lot of thing, at that juncture, I think that kind of independent study, further extra efforts, with the permission, of course, that cost is already approved, will be approved by COC.
Oh, of course.
And with the extra agency, it is helpful to the entire process, actually. Yeah, of course,
Yes.
mid-size case or small case, we cannot, but if this big size ticket. But that is that. Yeah. Anyone else wants to give the view on that case, please? Mr. Tirupal?
So we are discussing everything about what Supreme Court has already told. And suppose if it has to be liquidated, what is the procedure to be followed? I think there is some discussion is required from the seniors.
But
Suppose if it has to go into liquidation as decided by the Supreme Court. What is the role of the liquid?
your voice
What
is,
is
hello, your voice, there was a disturbance. We can't hear you, Mr.
okay? My
So
connection
you
is
are telling that what, if it is liquidation order is there, how the liquidator, what is the duty of liquidator?
Hmm.
That actually before that, lot of clarification will come and also the court has to decide because that liquidation order also will have, and he has to go for direction continuously to the court also. Like,
Yeah, NCLT has to give the order, I think.
and whether section 230 liquidation as going concern is not there, now how it will be different options. And
Going concern can be done under liquidation.
no, that is not there. I'm telling that section 230 and that also. So
Yeah.
again, stakeholder committee, SCC, and how it will they take
Hmm.
and with the consultation that liquidator has to, that itself is another liquidation proceeding. So even the state SCC stakeholder consultation committee will be formed and then it will be decided. But before that also there can be many things to be sorted out and you don't know how it will take up. So that process, yes, when law is
Yeah.
there, the process is there, but still the consultation and the consultation of the SCC and the court will happen, NCLT directions and all that, because now it will be precautionary how it will move. And lot of stake is involved. So even the return of money, because that is to be recovered, whatever payment is done, all that has to be, that process has to be worked out.
Yeah, it has to be returned.
Reversal.
Hmm.
And what about
It's a
the
lengthy process. It's not so easy because it's the
many
huge
issues
amount is
there, it's
involved,
not
and the operations have been going on from the
lot many
and
issues are there, no, that operation
many
is
issues are
also
there.
going on now in liquidation. It is a kind of a running concern. Now,
Running
the
concern,
order,
earning
yeah.
profits, earning
So
profits,
that liquidation order is also that time.
and there are avoidance transactions are there.
Yeah, so many things are involved in that. So that order itself is going to be that process. Before
It's
that,
a unique
only
of its kind, I think. I think never it had happened in the past.
so lot many clarifications will be required and I think it will be sought only. It can't be simple straight by liquidation order. There are many things for liquidation order also as well.
Was there any such case in the past? No, I mean Jata Airways and all.
No, not that way.
Not that.
Yeah, Mr. Deva. You are muted. You are on mute.
What happens if somebody else wins in liquidation? It goes to liquidation process, not JWS, somebody else gets the bid. Now JSWS spent so much money, other things to get into it. So they also have a legal right to go back. So how would that be taken care of?
JSW already having been identified as 29A ineligible can never go back.
No,
Okay.
he is telling other bidder will come, then they have already invested the amount. So that they are
Fraudulent investment cannot be compensated under any law. They have suppressed their relationship, so they suffer.
So whatever 200-300 crores they paid is a loss for them.
I mean, that is some, okay.
There's a
Whatever
recovery chance or
no,
there's a
they have
loss.
paid more than that apparently.
No,
Because
whatever, say 20,000 crores, whatever
so there
they
will be
paid.
an X amount which would have gone to creditors. Okay.
Right.
Some part of it may be expense. I think that they have to forget about as far as what is paid to creditor. Now that is a separate case which will go on, where the creditors might file compensation claims and it may need to be decided by a court of law which is outside ABC. It might be under civil law. Okay.
So it will be much more murkier than this, what appears.
Huh?
It will be very murkier. It will be murk.
Yeah, उसमें क्या है? There's
No, उसमें
nothing
कुछ
new in
नहीं.
India, Baba. Yeah,
It will
lots
be a
of
learning
people.
experience for everybody.
It
But-
it will give a lot of employment to lots of people, no, over a period of
Yes,
time.
yes, learning experience for everybody.
But this running operation of this running unit.
Nothing will happen to that, nothing to worry. In any case, RPs have a limited role to play in managing a business part of it. The existing employees and officers will do that. They will continue to do that.
And COC, this, of course, till that time.
It's a large company. They have senior people at the helm. Let's not worry
And
too much about it. They will
we have been
take care of it.
Yeah. Under
There's an undertaking reported, there was undertaking reported the Supreme Court on behalf of COC. The payment being made is subject to outcome of the pending appeal. So COC has, in fact, on 6th of March 2020 has agreed that they will refund the money to JSW. So that's undertaking recorded in the Supreme Court. Even if you read final order also, is there in the order. So the JSW investment is going to come back to JSW.
Going to come back, that is the,
Yes.
and of
Correct.
course,
Subject to any compensation claims, if any, filed by creditors and other stakeholders.
Those things will continue.
And that they can, and they might get stay orders, but that will be not in the NCLT forum, that will be in civil courts.
Yes.
So as far I remember, good evening everyone, Bharat Sethi this side.
yeah,
As far as I remember, there is an order which records the statement by the council of COC that the money which they have received will be refunded within a period of 2 months. So on that basis, they were allowed to, the COC financial creditors in the COC was allowed to use that money. And that statement was made by Mr. Abhishek Manu Singhvi, the senior advocate. So that money is going to come back, whatever they have done, except as Mr. Granthi said that the expenses which they have made, they need to forget it now. Expenses that's gone, but whatever money they have paid to FC and even to OCs, that will come back to them.
There is no,
In fact,
there is no, there is no
Or it
undertaking,
can become a claim in liquidation.
Yes.
understand.
But then that was an undertaking by the COC council.
Undertaking is
Not
by
the COC part,
undertaking by
yes,
COC
not the
council.
OC part. OCs
Yeah.
have not given any such undertaking.
Undertaking
yes.
on behalf of FCs.
FC,
By
COC comprises
Abhishek Manu
of FC
Singhvi,
only.
that was reported on 6th of March 2020.
That's what
There
I'm
is no
saying, sir.
undertaking on
COC.
behalf of OCs.
Sir,
Anyway,
COC
why are
versus
we
FC
discussing
आएगा.
about JSW? I think all of us put together are smaller than them. They can take care of themselves.
One thing I would like to add, this rule, this judgment has highlighted not only the shortcomings in the role played by RP, even the supremacy of COC has got challenged because of this judgment. Because of the shortcomings, the COC, the wisdom of the COC, which was given a supreme effect, that now has, which was even noticed in ArcelorMittal case, Asidhar. Now the terms are clear in this, more clear in this judgment as compared to other judgments, that the COC is also not infallible. Their judgment, their wisdom is also subject to judicial review in case those parameters are not fulfilled.
I'd like to make little distinction here. I agree with you in principle. What the court has said, court has not said that commercial wisdom is not supreme. What the court has said, they have failed to exercise their commercial wisdom.
Correct.
So it's not that everything COC does can be covered under the wrap of commercial wisdom. That commercial wisdom has to be exercised, and it has to be demonstrated that we have exercised the commercial wisdom, and this was the best outcome under the given circumstances. So that has to be now demonstrated.
Yes.
So the NCLT would get now some teeth to check whether the commercial wisdom is being exercised or not.
yeah,
Yes. Correct. Thank you.
thank you. Anyone wants to say a few their view on the case? please?
One more thing.
I think Mr.
they are
Singhania
able to
has been
hear me.
waiting and Mr. Katia has been waiting for a long time.
Sorry. Mr. Katia?
Yeah, thank you, Raviji. So I have 2-3 things to say. One is fraud vitiates everything. I think it is less to do with 29A. It's more to do with fraud, the conduct of the resolution applicant. That's how I look at it. In fact, I would go on to say that on a strict examination of 29A, they may have even qualified. It's the suppression and the non-disclosure which has led to 29A issue for them. It's not about being eligible or ineligible in 29A. That part has not been examined by the Honorable Supreme Court. In fact, Honorable Supreme Court has resisted to go down that path. They only observed on the conduct of the resolution applicant through and through. From the start till the end, the conduct and the fraud played by resolution applicant has been overbearing in the mind of Honorable Supreme Court. While Raviji has already pointed out the elements of fraud, but I'll give you one more fraud point, at least in my own assessment, which is that they committed upfront payments. They got H1 status, not a declaration, by committing upfront payments, and they were deliberately delaying the implementation of the plan. So that's a fraud. And that conduct was noticed by the Honorable Supreme Court. The other thing which I want to say is that the commercial wisdom of COC has been capped now by saying that it has to be in consonance with law. So far, the commercial wisdom was being played as the supreme. My sense is the commercial wisdom is now has to meet the test of the law. Somewhere in this journey, we were losing this bit, and now that stands absolutely clarified. Then my last observation. Is a lot of people are making a point that this judgment needs a review. In my assessment, while the review otherwise is also very difficult before the Honorable Supreme Court, this case has even narrower, scope to be reviewed by the Honorable Supreme Court because there is a fraud. The Honorable Supreme Court has observed fraud, misuse, abuse of process of law, collusion. Why does it deserve a review? The Honorable Supreme Court is not going to review
एक minute.
something
Dipti ji,
which is fraudulent.
Anil ji, hold on. Dipti ji, can you mute Rakesh Tulsian?
I was trying to that only.
एकदम disturbance आ रहा है उनके यहाँ से. हाँ, ठीक है. Sorry, go ahead.
Yeah, sorry.
Yeah, so all I was saying was the Honorable Supreme Court has observed fraud, collusion, misuse, abuse of process of law. This judgment, therefore, does not have a scope of review, in my view. The only element, if at all, which the Honorable Supreme Court may examine is the liquidation aspect, which Mr. Sahu is also saying that we need to protect the transaction. We need to protect the debtor entity. While liquidation process, if conducted properly, can take care of this also. It is not required, but still, some people may argue this before the Honorable Supreme Court, that the liquidation is a very extreme outcome. Therefore, there may be review from that perspective only, limited perspective. I don't see any other review coming because fraud vitiates everything. Thank you.
Thank you. I think you are rightly pointed out that there is a non-compliance, there is a legal breach, there is a flaw in the process, there is a concept of fraud here. In view of that, the person who has suppressed the information should not be given this thing, but the view should be taken, the care should be taken that at least the running entity which is now on should be protected and should not be closed. That is to be very well should be taken care while hereafter the whatever the process of liquidation will carry out. Yeah, Mr. Who else was there? Mr. Rasik, I think you are raised the hand since long. Yeah, Mr. Rasik.
Yes, ma'am. As far as I understand this case, financial creditors has given a declaration that they will refund the money if the case goes against in 2020. But operational creditors have not given any declaration. So now operational creditors are not going to refund. And in liquidation, as per section 53, operational creditors are not going to get something. So what will happen to the money which has already been paid to the operational creditors?
This will be, I think, handled separately as we discussed.
Again, a case will go for a couple of years on these matters.
Yes.
Rasikji, these are things which happen, which are never provided as such in law. So they will travel through the legal thing. There will be claims, counterclaims, litigation, vagera hoga. Somebody who has received money is never going to return it, saying that I was supposed to get it under that. And there also 53 was applicable, by the way. It's not that it was not. Okay. So to that extent, how will it happen is something which we have to wait and watch. It will take years. The OC issue, if they don't refund the money, which they will not, no sensible person, will not be decided finally, at least for the next 5 years. तो 5 साल तक आप आगे का एपिसोड देखते रहिए.
5 + 5, 10 years.
Yes. So, but in the context of the entire insolvency of Bhushan, the amount paid to OC is insignificant and not something which needs to bother anybody. वो अपने रास्ते पे चलेगा, बहुत छोटा चीज है.
But sir, whatever has been paid to financial creditor, there is a possibility that
Financial creditors have to return it back, but they will. If I am in their place, I would say, okay, I want to return it back, but I don't want to give it to JSW because I have claims and counter claims. I will give it to court. आप रखो जब तक ये final decide नहीं होगा. This is what normally happens when the amount is disputed. It is kept with the court by way of an FD, interest bearing thing. पैसा रहेगा जो भी है, and आगे 8, 10, 15 साल जब भी है, it will get decided and distributed, whatever it is. But I don't think the bank should return it back to them without agitating it. Just because some bank officers of a bank did not do their job properly, they are just employees. That money belongs to the people of the country. Okay. So somebody else coming in their place will have to do that correction. And no one can take the stand, oh, you two did this like last time as an institution, so you're bound by it. No. If what they did was wrong, or they did not do what they had to do, they have every right to correct themselves. They have a duty to correct themselves. So they should not agree to give it back to JSW directly because they have also been defrauded. Na? And that defrauding would have happened by way of means which are not legal.
Authority, which is the NCLT, to initiate.
Hello.
तो थोड़ा तो आपको म्यूट करना पड़ेगा बीच-बीच में. होता है ऐसे. Yeah.
I want to give a comment on this OC issue. See, I think the OC issue is far more resolvable if we put this back into CIRP. In liquidation, what will happen most likely is that the money will not flow to these OCs. The money that will come will only flow to the FCs. So these OCs are unlikely to refund. So that's the cost on the whole thing. So while I agree with Raviji completely that, JSW committed a fraud or an error or an omission, so they deserve to not to be paid back by the OCs. But I think if purely from a process perspective, under liquidation, I don't think OCs are going to participate because they will only participate if they have the incentive to participate, which is missing on the face of it. Thank you.
The thing is that government of Odisha's claims were not considered during CIRP. Now they will also come as a claim under liquidation.
Yeah. Dipti ji, I think Rajesh Agarwal is waiting and Devang.
Yeah. Devang Sampat and Rajan Agarwal. Yeah, Mr. Devang.
Let Rajan complete. I'll later on add.
Sorry?
Let Rajan speak first. I'll speak later. He's waiting since long.
Yeah, Mr. Rajan.
Good evening, everybody.
Good evening.
Devang is a good friend, so he has given me a pass. So again, a disclaimer from me, I have still not read the judgment, but whatever I have been hearing, lectures that I have been, whatever I have heard, from that what I can make out is that somewhere down the line, it is probably there is a collusion between the COC, the SRA and the RP as well. So there is a collusion. Probably they have been working hand in glove. Now, for such a huge assignment of CIRP, I believe the best of brains have been advising the RP also while he is conducting the process. So, I don't think there could be a chance that the RP forgets to complete the process of 29A or he forgets to attach Form H to the application for approval of resolution plan. So somewhere down the line, I believe there could be a chance that there is a collusion between all of them, right? Now, what came out in our discussions is that means the commercial wisdom itself, basically the supremacy is not called into question, but the Supreme Court says that the commercial wisdom was not applied, right? Now, even if you are entering into this territory, then NCLT benches on this ground that you have not applied commercial wisdom will start questioning commercial wisdom, which comes to my mind. And I believe there is a good case to question commercial wisdom because under the garb of commercial wisdom, much of the misdeeds of the COC have been accepted and orders have been received, right? Under the garb of commercial wisdom of COC. So a mention was made of Mr. Sahu. Sahu Sab, because his name has already been mentioned, so I would like to say what his views are. I heard him. So he says that this judgment is legally very strong, but economically very weak. So he says that the economics should have prevailed over legality because this whole law is based on economics and economics should have prevailed. So he went to the extent of saying, and I'm quite surprised and probably, so I believe that this judgment somewhere down the line will lead to lead to a overhaul of the whole law of insolvency. IBC probably will get a good rehaul on the basis of this judgment. He says that like in a share market transaction, once the transaction is done, executed on the stock exchange, then the stock market exchange ensures that the transaction is honored by both sides, right? Now, so this should apply in IBC law also. The courts have to ensure that the transaction once entered into has to be honored. And 5 years down the line, you cannot come and say that this transaction, now resolution plan which is accepted is rejected. So he was of that opinion, right? Now, coming to the review in Supreme Court, right? Now, basically, the review or curative petition, whatever you may say, right? So, basically, I'm personally of the opinion that generally this does not hold much water because you don't have any new grounds, you don't have any new information. Based on the same information, if you approach the Supreme Court, I don't believe a review petition or a curative petition will survive. But only on one count, probably Supreme Court will be pressurized into rethinking on its judgment is basically fait accompli, right? So basically, whatever has happened, and it is fate accompli, and now reversing that and putting the clock back, basically is it's going to create more trouble. Basically, they want to say that they also, those who are saying that this judgment is not proper, not in order because it has rejected the resolution plan after 5 years. So they say that the whole ecosystem of IBC is coming into question, and probably the SRAs would be the RAs would be apprehensive of going through this route. Means you will never receive a good resolution plan. People would be wary that after 5 years, what if my plan is rejected? And one last point I wanted to make. So generally, I would like always to agree to Ravi ji, but one thing I would like to mention, call out, stating that I don't think that the banks can put an argument that this is people's money and therefore we cannot return or we shall not return. there is the judgment of the Supreme Court, right? So when I said I have not read the judgment, I am still into the reading of the judgment. So this judgment makes a mention of a previous judgment. So I have gone through that previous judgment. It's a 2-page judgment which only mentions that the advocate of the COC has mentioned that they will return the money in 2 months. So if there is a specific order, you have made a statement to the court that we will return in 2 months, then I don't think you have an option of not returning that money as promised, or you can come out with new ideas as to why that money cannot be returned as committed to the Supreme Court during the proceedings and also recorded in an order. So these were my general observations which I wanted to share with everybody. Thank you for
Thank
listening.
you, Rajanji. It can be said that actually everyone is agreeing that, of course, Supreme Court, when giving verdict, it has taken into care of legal compliance, and they have to take care of legal compliance. Well, we can't say process. Process also has in IBC has its own importance. Like 29A is a very important thing, that it should not be in the hands of that culprit promoter. So that's why 29A, and if that you play with that, then again it's a question of the integrity. So that way Supreme Court has taken, but everyone is concerned that how this situation can be kept, that the company runs, the revival of company doesn't go back. That direction could have been taken care. So it's like it is expected that people are thinking that some direction or something on that part Supreme Court has thought, but I think that maybe at that juncture may not be the perfect point, because including that 29A, as you rightly mentioned, Supreme Court has not gone through much because it was not discussed in length during that arguments. They have pointed out themselves that the 29A, that disclosure and it is not proper, is done on that. Yeah.
Only one sentence, madam, only one sentence. So with respect to 29A, I think Raviji has beautifully summed up. He says if you have not done the process of 29A, the plan is void ab initio. If the plan is void ab initio, how can it survive? There is no case for its survival.
Yeah, Mr. Deva.
Nice to see many friends, including seniors like Ravi Bhai, Dipti Bain, Rajan Bhai, Munish Bhai, and many others. Now I'm putting certain. Okay. I'm just putting some points and facts. I'm not taking any sides. First of all, for operational creditors, they've only been paid 350 crores. The last pack, I think so, was 700 crores in the company. And even the 2.5 or 3 years of CIRP, whatever the company has received has gone to the successful resolution applicant. So even a CIRP period, whatever the cash flows were, positive cash flows, that has gone to JSW, so it is never at a loss. Second particular point, we don't have papers in front of us. Now we don't know what the submissions, etc. were. Why I'm asking this is, saying this is, Form H was never applicable in this particular case. And we don't know what the RPS submitted, because even this basic submission has not come on record. Including the 29A, the order says that there is nothing on record to show that 29A, this affidavit was received. Only there were some schedules, etc. And this was discussed in 14th COC meeting. But what were the submissions of COC, and maybe of course the COC submissions are there, RP submissions are not there. So whether after suspension even RP was taking interest or not, next important point is,
Mr. Deva, the voice is cracking. Can you repeat last sentence, please? You will lost the connection.
Yes. Now, what RP was, maybe submissions are, we don't know. Whether also. Now,
Mr. Devang, I think there is a disturbance.
Devang's network is probably very weak. He's losing it, fading in and out. Yeah.
Is it clear now or still unclear?
Sorry, now, yeah, now you can speak because.
Okay. Now, even for this particular application, this JSW, beginning, so fail to understand what JSW loses. It had a plan which was in its it is getting back the entire money. Only it says of increase.
Devang, your network is really, really bad. We can't hear you at all.
I think so. I'll have to fix my network. Correct.
We are unable to hear Mr.
नहीं
Devang.
आवाज आ रहा है देवांग. Just not able to hear.
Initially, we were able to hear, not now.
See, with the network issue. Hello.
Hello.
Network issue. Network issue.
Okay, can you put on the chat, Mr. Devang, what you want to say?
Uh,
That's also fine.
Devangji has made a point that at that time, this 4 match was not applicable. So I would like to slightly correct him. This application for approval plan was filed in February 2019. That's clear from the order. And 4 match was introduced in January 2019. So by that time, RP filed this application for this thing. The 4 match was already in the regulations. This 4 match was in fact discussed in a meeting in August 2018, finalized somewhere in August 2018, that but then IBY somehow kept waiting, but it was introduced in January 2019. So by the time application was filed, 4 match was applicable.
Yeah. Anyone else want to say, please? I think now that.
My name is
Yeah,
my
Mr.
name is Kashi. My name is Kashi Vishwanathan Shivaraman. I have a question. In what capacity the RP was working when the resolution plan had been approved by NCLT and he conducted a COC meeting for what to say, giving an extension that the resolution plan will be updated or whatever. The JSW has said that they will make the the implementation of the plan on a different date. On what capacity the RP was working? That is a question of mine. Because once the resolution plan is approved by NCLT, the operations goes to the SRA and to the monitoring committee. If I am wrong, please correct me. In what capacity he conducted a COC meeting after the approval of the resolution plan?
I think there was a monitoring committee and he was the part of the monitoring committee and the COC.
No, but one thing is there was a COC resolution of 97.5% voting share which was given for revised implementation date. It was in 2019, it was brought back to 2021.
That was
March
pointed out.
2021.
That was also pointed out by the Supreme Court, I think.
No, that extension and revised was under the orders of NCLAT. So that is legal because the JSW itself went to NCLAT against its own plan. It sought extension, it sought modification, it sought various things, and they got a lot of it from NCLAT. So, in a way, you can say the CRP got reinstated for that limited purpose of whatever those proposals were there.
Yeah, depriving
so that part is not illegal. What has been flagged as illegal by the Supreme Court is that NCLAT had no jurisdiction to do such things. So you can't blame the RP for that part because he was following NCLAT orders.
Okay. Thank you, sir.
Anyone else?
Yeah, one point which I think economic criteria for deciding on probably people are maybe a bit more apprehensive about it. I can tell coming from a corporate background that, as I said already, and I'm repeating it, there is nothing to worry about running of JSW. Bhushan, still it will run properly. Chinta mat karo. Even in liquidation, okay? Because here I can say from personal experience that under liquidation, one company is doing far better than it ever did when it was under previous management. Okay. Oh, hota hai. It's how you manage it and what are the circumstances under which you can. If a dead company can never be brought back to life by anyone, but that which is running and which was running, which was apparently the case with Bhushan, not something to worry too much, but there is one caveat. And this is important that it is now incumbent upon the members of the COC to meet immediately, come to a consensus and go to NCLT and seek the appointment of an IP immediately, who could be, the liquidator's appointment has to be done over the next couple of weeks and not the next couple of months, which they normally tend to take. And because of the seriousness of the matter, I am pretty sure the NCLT will oblige them by hearing it and giving order on the same day.
Right.
But I am not so sure that the banks and our lenders can agree on a name for the next 2 months.
Yeah, otherwise NCLT would
They
appoint.
find that out because
I
account
understand
management-
that the promoter has gone to NCLT for liquidation proceedings.
Yeah,
I
yeah.
understand that.
The promoter
Yes.
will go, nah, see, this is all for promoter, okay? And I mean, in the sense, they would always like to put a spanner in the works and doesn't matter what is the outcome of that. मुझे मिले ना मिले उसको नहीं मिलना चाहिए. That is always the first principle. So forget the promoter. I mean, he is irrelevant in this. It is the lenders and it is their duty. And we just hope and pray that they do it very quickly because they don't need any further time. They can go to NCLT on Monday and get an order on the same day if they want to, considering the urgency.
They're going for review petition. They're not going for liquidation.
That is
They have
exactly
already-
the problem. That is the whole. See, the review can be parallel. That is what they have to understand. That they can file a review. That is a remedy which is never taken away. But because liquidation order can always be reversed. See, what you are not here asking for liquidation per se. You are asking for the appointment of somebody, and that somebody, the only designation possible under law today is liquidator.
Now, I was just speaking to the point, what does JSW lose from this particular order? I am asking to myself and everyone. It is getting the full money back. The plan is set aside. The plan is not paid. So the financial creditors have to pay back the full amount. Whatever it is paid as CRP cost and to operational creditors, more money has come in as cash flow during the CRP and during the last 4 years, which is there with CD. So it is getting 100% money back. All it is losing is, if it says it has expanded the capacity, maybe even that expansion cost, if it has not come from the cash flows of the company and it has gone from its money, that is possibly the only amount which it can lose. Otherwise, it doesn't lose anything except for the Section 74 order which has been issued to IBBI. So, and who are losing are the investors who have invested in JSW. Even the money besides 100 crores of equity, it is put in form of CCDs and OCDs. So even that money, it is absolutely taxable beneficial. I fail to understand what JSW is losing. Of course, I don't have the entire papers in front of me. But maybe the media and everyone is saying it's against JSW. I don't find anything is against JSW.
Because they were
totally
stamped as fraudsters. No, that is the issue. Monetarily, they may not be losing, but the prestigious loss is there.
JSW is losing a flourishing business of Bhushan Power.
But the thing that we are telling that it is mentioned JSW has JV with and connection with Bhushan, and the promoter that Bhushan itself is going for liquidation.
Yeah, everything fishy.
Because we are telling that in resolution plan, the resolution applicant is having connection with the Bhushan Power. That's why 29 is into question. But Bhushan Power itself is going, the promoter itself is going for liquidation.
One point I want to bring to the notice of this gathering. See, like in this order, this judgment also, in the end, the Supreme Court has used Article 142, right? Now, 142 nowadays has been dubbed as the nuclear option, right? That is what it is called nowadays. So, what I personally believe that why for everything in an economic law, rather, I would restrict myself to IBC judgment. In economic laws, why Supreme Court has to resort to this Article 142, which basically means that whatever it may be, but we believe this is the correct position, and therefore we say that this should be done because we are saying this under Article 142, right? So I believe in economic laws in IBC and all, the need for resorting to Article 142 should not arise. That is my personal opinion.
Now, Article 142 is being completely at the discretion of the Supreme Court. They themselves would decide when it will apply and when not. It's not something that you can have a standard SOP as to you can use it in this manner and only for this. But coming to this, in this particular case, when I read this, the question that came to my mind, which I just don't have an answer to, is maybe even Section 11 would have applied. And the same order could have been passed. Because ultimately, what have they passed? They passed order of liquidation. Net effect is that only. That resolution set aside on whatever be the grounds. So when a resolution plan fails, the next step, naturally under IBC, is liquidation. So why you even mention Article 142 when the code itself gives that power? So
yes, exactly. Then JSW would have been in total.
I want to react to that actually. That's a very
I'm
interesting.
just thinking, no answer. This is not an answer.
No. So my sense is I've just understood what you're saying, and my take on this would be that because this plan was implemented, that's why Article 142 would have been invoked. It would have been in the mind of Honorable Supreme Court at that time that they should. Article 142 is used to meet the ends of justice. In the wisdom of Honorable Supreme Court, they would have felt that they should not leave any legal point open while passing such a stringent order. That would have been weighed in the mind. That would have weighed in the mind, and also the fact that this plan was already implemented. I think that would have played out in their mind. That's my take. Thank you.
May I come in? 2 sentences. So
Yeah, please.
So basically, when I say that in economic laws, Article 142 should not be used, that is just opinion. And at the end of the day, sir, absolutely, it is the prerogative of the Supreme Court, Honorable Supreme Court, to decide when it wants to use Article 142. It is the right that they have under the Constitution, right? Now, Mr. Anil Katia has actually said quite appropriately that they must have weighed all the legal options and they don't want some litigation ahead, and therefore they have used the option of Article 142. What comes to my mind last is when Raviji said that it is for them to decide. I'm going too far, but kindly bear with me on this. We are just trying to understand. So, did the framers of the Constitution, when they gave power of Article 142 to Supreme Court, did it ever probably occur to them that this would be used in economic laws? Question mark. I don't know.
So let me react to that. We are actually overplaying the word economic law all along, including Mr. Sahu's, with due respect to him. I'll tell you why. This judgment is less to do with economics, it's more to do with the conduct of the resolution applicant who played fraud. It's a court-sanctioned scheme, for God's sake. You cannot have in a court-sanctioned scheme a fraud, a collusion, an abuse of process of law. You cannot. The Supreme Court cannot close its eyes. I don't think the economics or the economic law thing has played out. And I would also like to comment on Mr. Rajan Agrawal's point that Mr. Sahu said that economically it is a hollow decision and legally it is sound. He also quotes the securities market practice in that. He comes from that background. So excellent point. Conceptually, I am with Mr. Sahu, but even in securities laws market, if some companies raises money through IPO and they subsequently are found to be fly-by-night operators, that money doesn't come back to the investors. The investors lose that money. So it's not so out of line, you know. Whatever Supreme Court has done is absolutely in line. Supreme Court has read the law and applied the law. That's what they have done. The plan has to fail. The plan has to be rejected. So the company has to end up in liquidation. That is the law. So that's what Supreme Court has done. So the only maneuver that is available for the review, like I said before in this discussion, is that somebody can stand before the court and argue that let's protect the debtor entity, let's protect the transaction. Maybe we are better off pushing it back to the CIRP rather than having a liquidation. Somebody can argue that. That's the only limited argument that can stand before Supreme Court. But I don't know who is going to argue that point. That's another question. Thank you.
Supreme Court had other options also apart from restarting the CRP. They might have see if there is a fraud, if there is some misconduct, then they can penalize them, penalize RP, penalize whosoever. But after 4 and 5 years, just rejecting the plan, it gives a very wrong message for the IBC system. I mean, there are so many other options Supreme Court could have, exercise, penalize whosoever has done wrong. But it is putting entire system in a such a dark way. It's something can be avoided.
I just, if I may, looked once again. I was not recalling the section number, but now I saw it is subsection 3 of section 33, which addresses this situation not fully but largely, but still leaves a gap, and which is possibly what was the reason for bringing in the Article 142. Subsection 3 of 33 talks of where the implementation of the plan has failed, which means it says corporate debtor has contravened the provisions of the plan, which is what is the conclusion of this judgment, that this has been contravened in many aspects, including having been ab initio null and void. Then the option available under subsection 3 is liquidation. In fact, there are no options for going back. Once CRP has commenced, except the withdrawal under 12A, that is the only option. So if you remove 12A, the natural progression is CRP is always to be followed by liquidation if CRP has failed, for whatever be the reason.
Liquidation.
Now 33(3) was talking of an application made by a person aggrieved, any person. And this is also what is referred in the judgment, that this operational creditor whose locus was challenged, they said he is covered under that broad category of any other person whose interest is affected. But because it said that at his instance, now in this particular case, the OC might not have made a prayer for liquidation. They might have made a prayer for something else. But since no other relief is possible, then it has to be liquidation. So 142 had to be resorted to, because last jump karne ke liye 33(3) was not giving enough power.
Sir,
Udairaj Patwardhan here. I am not able to.
Sorry.
Video, sorry. But
हाँ नहीं आप बात करो यार, सुन रहे हैं.
Switch on my video. Sorry, I am traveling.
No.
Couple of things I wanted to add. What Raviji said, I will take it forward, particularly about appointment of the liquidator, etc., by the Committee of Credit. Who the RP or the liquidator is going to be? They will be worried about who the process. Because all these cases, big.
Udairaj, your network is bad. Can't hear you.
The country of the world. If I would, the big 12 cases, the bad 12 cases were taken up by all the big advisors of the country. The RP was irrelevant in all the cases. So even in the current situation, who the liquidator is going to be is not the problem. Who is the process advisor or the IP is going to be is the problem with the COC one. And another is who the legal advisor is going to be. because those two have no comments against them in this order. The process advisor, the IPE, and the legal system, the legal advisors who took crores of rupees in advice in these cases, there is not a word against them, not whisper, not even a discussion against the role of these people in this whole process. So I wanted to just bring it to the notice. I am not commenting against anybody's role, but this is a very important thing which everybody has ignored, because these 12 cases were simply grabbed by the advisors, that I will take this one and you will take that one. That is my just. I'm very much with the Supreme Court judgment, so I am with everybody. But this is my observation, which is little tangent from what is mentioned in the order.
If I may say, since you brought up a point which I had actually missed out, great point, as to who will take action against the. Now, this is actually an opportunity to IBBI to set, because this is in the domain of IBBI and not in the domain of the courts about disciplining professionals and process advisors. It's all part of the regulation and they can do that and they have the power to do that. This is what they probably get a chance now to see what best they can do in terms of regulating the advisory entities and not going after the chimera of trying to regulate banks, because that is never going to happen. Banks are under RBI and only RBI can regulate them. Anybody else can keep dreaming about it. But the support system of the RP of the regulator or the liquidator is definitely within the domain of IBBI, how they can do it. And they have to do it through the RP, obviously. That give more power to the RP and more accountability to the RP to do the selection. Both.
My take is a bit different. I think very consciously when you participate in an IBC process, the risk owners are very well known to everybody. There are primarily two risk owners in an IBC ecosystem or in an IBC process, which is a resolution professional when the process is running and the resolution applicant. So I think we will make it too complex by bringing everybody into this controversy and trying to make everybody accountable. In real life, that doesn't work. That's why these people are always on sidelines. They have chosen to do that role because they don't want to play this risk. The ones who play the risk have to bear the cost of that. So that's the way life works. That's the way the world works. We shouldn't be worried about the fact that Supreme Court did not indict them or commented upon them. They are not to receive that from Supreme Court, in my view. It is only and only the resolution professional and the resolution applicant who has to bear the consequences, in my view. Not even COC. COC is just a body to decide. They will bear the consequences of their decision by the very decision of the Supreme Court, whatever those consequences are, good or bad. So it is that will fall upon them. So I don't think we need to stretch ourselves thinking that everybody has to be penalized. And somebody said, what penalty we could have given a penalty on JSW? This is the penalty on JSW. They are getting their money back. They are getting a very good escape. The rest of it is all penalty for them. They will not be able to own this debtor entity. Is a penalty on them. That's the penalty Supreme Court has chosen for them. And also they will possibly lose some money here and there. Maybe, the interest on this capital which will be returned is a loss to them. Maybe the money that they have given to operational creditors doesn't come back. Most likely that is a loss to them. That is the penalty which Supreme Court has thought fit to be put on them. Look at Jet Airways, 350 crores forfeited of a resolution applicant. So on the same level, JSW will also end up losing maybe 350 crores to 500 crores. That's the penalty. Please. Thank you.
Sir,
I may
sir,
disagree
sir,
to this. I
yeah,
may
I'm also
disagree to this to
disagree.
some
I'm also
extent,
disagree.
just because of the two things which I see is all the people who are making noise about the decision being bad are only those two set of people, the advisors and the legal fraternity. Only those two people are making noise that this is a bad judgment. That is what my observation is. I will not argue further. I agree with Anilji that everybody cannot be penalized, but the person who advises and takes money home and quietly makes arguments that this is good and this is bad without being given put into the heat of the responsibility that they are going to take or not take, that is not proper.
But
That is what.
May I?
I'll just,
But,
I'll
but
just,
I am agree with Mr. Katia because you
I'll
know
just make one
the-
point. I'll
the-
make a very small point.
Yeah.
This is a market process. Thank you.
No,
Only
but
one thing that, sir, I need to.
I agree with him because legal profession is also under regulatory control. They are totally under control of BCI, so I doubt whether IBBI can control them. And secondly, what this order categorically said that the RP should not be a facilitator, but also a vigilant person. So whatever advice he has been given, maybe a wrong advice or right advice, I am not going to that. He should play his prudence. And sir, I mean, Ravi sir, to reply you, sir, COC has dual responsibility. I fully agree. As a banker, they are under the control of RBI. But when they come and sit in the seat of Committee of Creditors, they are under the purview of IBC. So according to me, proper framework should be done how they will discharge their function while they are discharging their function as a COC member. And if we say that it will be controlled by RBI, I have nothing to say on that.
Sir, one
Hey,
question.
actually,
That
this
whether the JSW shall be barred under Section 29A now?
So just one. JSW is not
The
losing.
design, sorry to interject, let me just say a very small point. The
Yes.
design of the law is, the foundational design of the law is, the COC will bear the cost of its own decisions. That is the design. The whole issue about the conduct of the COC, the way COC conducts itself, is overdone. We have to leave it. COC will conduct itself by its own free will. Reserve Bank of India cannot be expected to come and regulate the behavior of COC as a COC. RBI can only regulate behavior of individual lenders through its circulars, not COC as a body under IBC.
Right.
That is stretch. That is too much of a stretch.
Absolutely.
And rightly we discussed that point also, that Supreme Court with this point, they have also taken into consider the COC, that wisdom they have not properly used. And that is some signal that how COC has to behave. That is also pointed out.
The commercial wisdom is totally different from the guidelines of RBI. That is totally, I mean, when they are sitting in the chair of Committee of Creditors, they have to play for that. And I think for this purpose only, there should be a proper guideline.
Can I make some statement?
Yeah, please.
Yeah. Hi. I know that with my view, I'll be certainly be more unpopular. I certainly feel with full conviction that this current judgment was not the way the intent, what they wanted could have been obtained. And they have definitely gone ahead, and it has far-reaching implications. While everyone is looking at only JSW as the implication, I don't believe, because I also come from the industry. Second thing is, this entire IBC process with this judgment even more hijacked by the entire legal system than it being a business and the economics as far as the bankruptcy processes are concerned. This particular judgment actually ensured that it is not the people who are guilty to be punished in a particular manner. They have actually punished entire system, and the trust factor in this particular process also has a challenge. Now, someone can argue out, no, everything will be great, people will believe it more and all that stuff. It is not so happening. In a financial world, it's called as uncertainty. It's the moment there is an uncertainty, the risk has increased, the cost of this entire process has increased. I think this has far-reaching implications. We can always talk legally as much as possible that it is good, bad, ugly, and all. In the contract law, if you do it in good faith, that also is allowed. Now, Supreme Court has used 142 in the many cases wherein they have said this is not a precedence, and they looked at an exception to that scenario and tried to give a solution which is giving justice. And that is why Article 142 is used. Here, what they did is they have tried to revamp this entire thing, saying that we are supreme, will not allow anything, as if they have never used such kind of 142 powers in all other cases. So our plan, which is an important big event, big item plan, looked at by many in the industry, probably many investors across the globe, they have created uncertainty by these actions. And what are these actions? We have a select set of individuals. One, of course, is an RA. There are various ways to punish the same. RP and couple of representatives in the COC, they could have handled easily in a different manner. So yes, I know everyone saying here, I could hear many here saying that this is right and is good and all that. Personally, I believe they should not have used 142 for this purpose. Yes, there are many other cases. There are so many cases in NCLT, NCLT, at multiple stages this has gone through the legal system. Then it has come to Supreme Court. So the various aspects. So now today, no matter what happens, every person has to look at, did anyone do wrong? No one knows who is doing wrong here then. Because anytime Supreme Court can say, well, I'll reject this. So this has far-reaching implications. Yes, we can all be very happy. Suddenly justice has come overnight. Things have gone. Someone is being taught a lesson without really looking at the impact on the larger ecosystem. I am reasonably certain that such uncertainty should not be caused, especially when certain things are too big to fail.
One,
Yeah.
140
I-
could have been used to restart the CRP as such. Why to start liquidation? You can pass any order under 142, start CIRP again.
I also fully agree with Ganesh ji that this judgment is major hammering on the value maximization, because this judgment has added a big risk for the all prospective RAs, that look, this is one of the risks. Even after 10 years, your resolution plan shall be challenged and rejected. So this risk, everything risk and return is associated. Now this is added, and it will definitely hamper on the value maximization. That they will value accordingly as per the new added risk. Thank you.
So this judgment is not Supreme Court's failure. This judgment is actually the reflection on the institutional capacity and capability below it. And the Supreme Court could not have ignored such a large scale conduct issues across the board, and conduct to the extent that there was fraud and collusion. So please understand and appreciate, this is not about Supreme Court. This is about people under it who were manning the system, who were the gatekeepers. They failed. Supreme Court had to send a message. So they did it. So I partly agree with this criticism that this transaction, the way it has unfolded on the economic scene of India, is a definite issue. I am for a moment not disagreeing with that. But how do you solve this issue? Supreme Court is solving this issue. It's a court sanctioned process. The institutional capacity and capability has to undergo a change. It's a reflection, it's a message to the government, it's a message to the larger ecosystem that please change. You can't play a fraud with the court process. And that will hold forever, no matter who is sitting there. Thank you.
I think all these objectives could also be met if instead of passing an order to liquidate under 33, they have passed an order for restart CIRP. The GSW gets punished, COC gets a message, everybody gets a message.
No, so
Why to start
please,
liquidation?
let's not blame. So let's not blame Supreme Court for that, because that is not a provision of law.
No, sir. Sir, the only difference, sir, with due respect, you are right, absolutely right. If the intent, let's understand, if the intent of the Supreme Court is to send in a larger message to system across that they will not allow or let loose people to commit fraud. If the
Absolutely.
if no, perfect, fine.
Yeah.
Then the question that comes to it is, if in the same argument, I would have loved to hear why Supreme Court did not take an alternative. They should have put up in the order itself. The reasons are as follows. What happens is the messaging the Supreme Court gives, good, bad, one direction, other direction, there are larger implication ramifications. I'm saying that the same judgment Supreme Court would have taken it. I'm okay with that, provided they had enough reasoning why alternate options were not considered by Supreme Court. Because that is the power of 142. If the intent was clear, we are all understanding intent. Why are we are not even questioning. End of the day, as I think one of our fellow panelists and whom I respect utmost Supreme Court is the final authority. They need not be the right authority. I think I keep remembering this. This is exactly what's happening is if their intent they could have exercised in a different fashion, believe you me, in the finance world, whether it's the right decision or wrong decision doesn't matter. Did it cause uncertainty? And that uncertainty has a larger ramifications.
Uncertainty will be only temporary. Maybe
No, so that has
time.
a what
It
I'm
will
saying.
not remain forever.
You are absolutely right. What happens is when a bank fails or when a financial system fails, things will come back, right? When S-Bank failed, it came back. When Global Trust Bank failed, it came back. It takes time, but that is exactly the problem. First of all, the companies are insolvent. This law has become a compliance law. We all agree to that many a times, any which ways, rather than a business law. Now, added to that, we have added uncertainty. It's not.
See, that is unfortunately, that is the legislative scheme. It's not about intent. We have all been also saying this about Supreme Court, that Supreme Court should function within the realms of law, within the four corners of law. So in this particular case, these judges looked at the IBC scheme in totality. They have passed an order which is in line with the scheme. And I have already said that definitely there is a case for review only to the extent of putting the company back into CRP versus liquidation. That review, Supreme Court can examine if somebody argues that. See, please understand, this issue was not before the Supreme Court when they passed this order. They passed this order in their own wisdom. Nobody explained this to Supreme Court at that stage because nobody would have imagined that this is coming. So nobody argued in favor of CRP. One more CRP. Please understand. This is how it works.
So I would like.
No, sir. One side, they were saying the 12A is mandatory. So how would they go for another CRP?
So they can invoke. So that is Article 142 invocation.
Under 142, they have power irrespective of 12A or whatever.
From an intent point of view, not from the law point of view, sir. You are right. That is the whole controversy here.
Irrespective of whatever the law, under 142, the Supreme Court has power. They can reinitiate a CRP.
Then people have criticized Supreme Court for doing that.
People is already criticizing.
So Supreme Court gets criticized on both sides. So they choose this versus that. They have a criticism.
Actually, Supreme Court has so many options. He can refer the matter to IBBI against the resolution professional. He can refer the matter to the IBBI disciplinary action. He
that
can
is
also
already underway. The RP in this case is already undergoing disciplinary proceedings.
That is the option. But
he was given show cause notice in 2019 also.
Yes.
Yeah. If I may, why the Supreme Court did not consider resetting to the CRP, what comes to my mind, based on logic, that going back to CRP gives you the option of liquidation again, which means again a two-phase process, which might continue for years. So they have closed it by saying first option over, gone, done with, dusted. Now you have liquidation. Liquidation doesn't have a timeline. The one-year timeline is extendable infinitely if required. Liquidation does not prevent you from selling as a going concern. Liquidation today, as it stands, even a scheme of arrangement under Companies Act is being allowed, even though ILC in its own report said no, it should not be. So all the options which were available under CRP have been made available, but at the same time, by saying liquidation, they're saying you can't have a remake of a bad movie, which is what CRP would have probably been. I mean, this is just my inference from what has happened.
I would come in here. My only question to this gathering is, should the Supreme Court be concerned about the outcome of its judgment? Suppose if it is delivering a judgment on the basis of the facts, merits of the case and the position of law, should the Supreme Court be really concerned about what will be the outcome of this judgment?
I will respond before you finish the question. Especially in 142, Supreme Court has to be 100% conscious of the outcome of the judgment. 142 is placed in Constitution only for this kind of situation. 142 is when the every law fails and law results in injustice, the Supreme Court in its wisdom has to do the justice and think of the outcome 100 times before it passes an order. It's a total misuse of 142 power by Supreme Court.
Manish, 142 has been utilized in this judgment. It only shows to go that the
not utilized, misutilized.
sir, that is
Yes.
so what I say
I just want to say here that, I mean, since there is no COC now,
based
so
on
it is better if Supreme Court mention in its order that it can, the liquidation will be on a going concern, sale on going concern basis.
Or
Because
can it
who will take the decision? That
can the
whether it is-
second highest
No.
bidder be given a chance?
That is not the correct understanding. The moment liquidation has been ordered, a COC becomes the first SCC.
Yes.
It has happened already. All it requires is appointment of the liquidator, nothing more. Liquidation has already been ordered. No more NCLT has to order liquidation. NCLT has to only appoint the liquidator and nothing else is remaining.
Yes, take it on record. That's all.
Yes.
Absolutely. And I think we must.
Liquidation is, I think, it's not so easy.
So, all of those interested in doing the assignment, go and apply for becoming the liquidator.
Can JSW be a
We'll term them as a lucky liquidator.
Can they give a claim now?
JSW, it depends on what happens about that money. To the extent that they are refunded, there will be no claim. To the extent they are not, they will be entitled to file a claim. And whether they will get anything out of it is a different thing altogether. In fact, they would be silly to file a claim because it is likely to get extinguished in liquidation. Though it is better for them from a legal perspective to say that it is a right which precedes liquidation.
And
which
perhaps
means,
they are related party also.
and try to take it.
No. We are talking of the money they have put in terms of the CRP.
Yeah. No. When they are going to claim under liquidation, the remaining amount from the...
Yeah, all the other things will come. First, they will be at the
They
bottom.
will file the claim. No one can be stopped. And why they will not file the claim? They will file the claim.
And what's about
No,
section?
they might not file a claim because it might get extinguished. They would go and file constitutional remedies which will try to derail the process.
Yeah, apart from that, cannot they
have.
But why are we concerned about JSW? They are much bigger than us. हम उनके बारे में क्यों सोच रहे हैं? छोड़ो यार.
Absolutely.
What the Supreme Court order says is, Supreme Court says in the operational part of the order that money paid by JSW to OC, FC, and in the form of equity infusion has to be dealt with in line with the undertaking given by Abhishek Manu Singhvi on 6th of March 2020. So that money has to be refunded. That's the Supreme Court order. Whatever happens in liquidation, there's no question of filing claim or not filing claim. That's Supreme Court order. Unless somebody gets challenges it, gets.
Sir, we are talking of over and above this money.
Expenses also, no, Mr. Munish?
We are talking of money over and above this, sir. Whatever is covered under Supreme Court is not in question.
ठीक है सर, वो ठीक है, वो उसको फर्क नहीं पड़ता सर. अनिल साहब, उसको फर्क नहीं पड़ता.
Filing claim would not be beneficial for them because they are not getting anything.
Yes.
Secured lender will get.
Yes, and there is a way they can approach it. Of course, that is not something which we should be discussing.
We should not be discussing. They are much bigger than us. Here, they've got the best lawyers in the country.
Yes.
हमारी औकात कहाँ है?
Yes. That is for point more than to find a way.
But now will they be considered as? Sorry, one thing. 29A, will they be qualified for another unit or for this also under liquidation?
The 29A will be relooked at if they do apply. It has to be okay. Based on the situation at that point of time, the liquidator will have to necessarily go through it. If at all they file for sale as a going concern, then it will be examined because Supreme Court has not delivered a final judgment on the admissibility or otherwise. They have just said that you have ignored it and it can't be done.
And in my view,
it was told that
in my view, they are ineligible
because of the joint venture with VPCL. They are not eligible.
That's okay. That's joint.
They have to given the decision.
That decision hasn't been given.
Prima facie. Okay.
That is
they
not
have JSW would have every right, anybody for that matter, to say no. This joint venture doesn't fall within the entire
Meaning of
connected party and related party. It
Yes.
was for a particular purpose. It had
Yes.
its time. It was extinguished. See, if you look at it that way, if you go back to SR judgment, in the passing remark, they have said that just because two brothers have two different businesses, they are not related parties under IBC. Always. The relationship has to be in business, not by blood.
So this was a business relationship. That the reason the NCLT.
No, whether it extinguished. See, why are we talking about it? I am saying that will be examined by the liquidator at that point of time. We don't have all the facts to know whether they are eligible.
हमेशा कोई liquidator बन सकता है, will get a guidance.
Huh?
Somebody from among us can become a liquidator. Will get a guidance.
That's what I said. Look at that. Yes.
Sir, may I come in? I just
सर उसके लिए सर
इतने बड़े
उसके
CIR
लिए मैं वही बोल रहा था कि आप मैं लिक्विडेटर नहीं बन पाएंगे, उसके लिए कोई आईपीई या प्रोसेस एडवाइजर बनेगा, वो किसी को रख लेगा लिक्विडेटर.
Okay.
Madam, just one or two sentences. I really wonder where in such a big assignment whether the RP or the liquidator can remain unbiased. मैं मतलब विचार कर रहा हूँ मतलब whether he will be permitted to do that. And secondly, a suggestion has come that opinion has come that because of the judgment now, people would not want to bid. RAs would not be forthcoming for big projects. Like मेरा एक ही मानना है, जहाँ पे गुड़ है वहाँ पे मक्खी आएगी. कोई टेंशन नहीं है. अगर आपके पास में एक अच्छा एसेट है, उसमें शोले पिक्चर आई थी, शोले पिक्चर में कैसी लाइन लगी थी वैसे लाइन लगेगी उसका. इफ देयर इज अ गुड एसेट यू विल गेट गुड रेजोल्यूशन एप्लीकेंट्स. वन शुड नॉट वरी अबाउट.
Only that it is a message to the applicant that if you are doing any fraud or anything or any stakeholder, then it has issue even after 4 or 5 years. As and when it is found, it will be having its impact.
Which is right. Nobody should be able to get away with fraud. Nobody.
Yes. Undoubtedly.
So that's right.
And it is before Supreme Court, how Supreme Court is expected not to go through that the fraud which is there and it is reported. They have to take into consideration.
Process में खाली कमाए,
they can't ratify the illegal things.
I would like to compare this with one other judgment, which is also held this way, which has not invited this level of scrutiny or discussion among IPs, the EBIX judgment. If you look at the facts of EBIX, what was wrong with an RA saying कि if you take too much time, I have to get the right to withdraw. But that was closed. Now that is much worse than this one, because here, this is a consequence of deliberate action on the part of the RA. And that was where the RA had no role to play and still suffered or would have suffered. I'm not getting into whether IBIX was a good party or a bad party. No, the very ratio of the judgment is actually much more harmful than what is of this one, because this is very specific. Criminality found, criminality punished.
My one question to all, learned speaker, that why the role of NCLT and enclave was not much discussed in this thing, because they are also the authority who can find out the fraud or whatever.
Oh, that has been done, sir. Now you look at, you appear in any NCLT today and you see how the approach has already changed.
Sir, approach has already changed, sir.
Yes.
Now they are worried about the timelines. They are not even ready to consider for a day.
Yeah.
Sir, try to get 12 extension today. It's almost impossible.
Yeah.
And for some cases, where it is genuinely required,
Judgment.
extension, they are not agreeing to give.
Benches are quoting this judgment, sir.
Sir, I want to ask
One way, I
small
think it is a
question.
good development also.
Okay,
But-
I think with this, we can close this discussion, or anyone has to say something or have some view other than what we discussed, anything new? Or
My
views?
point is, Shivaraman here, ma'am.
Yeah,
My point is with regard to the resolution plans of the, the real estate projects. Based on this judgment, it will have its own ramifications, because the approvals are not being given by the land owning authorities, and it has its own ramifications on that. I would request the members to just say some points on that. What will be the ramification with regard to real estate projects?
So I'll make a short point. Whatever real estate resolution plans that are being filed by the resolution professionals before the NCLT, most of them are illegal resolution plans. And I've seen many. I'm not just making a statement. I've gone through them. If they are not being approved by these authorities, because they are illegal plans, they don't make any sense. That's why they are not being approved. They deserve to be rejected. That's why they are having this fate. Thank you.
But sir, I have a point here. I fully agree. If you go for such a strict compliance of the timeline, maybe we will not provide any natural justice to the home buyers, especially home. I'm talking about the home buyers. So I think it should be considered. I mean, at least for the home buyers case. Because firstly, because of the complexity in the CRP process, the time is really, cannot be kept. And if it is so strictly followed, then everything will go for liquidation. And you know that home buyers are unsecured. And,
Number of stakeholders.
No,
and
so I disagree with this. You have to have the creditors have to appoint the right people. If they are not, if they are just going after choosing an RP by somebody who is quoting a low fee or somebody who has some connection with the creditors, that is not the way. They will meet this fate.
But
They
sir,
will
here the
meet this
RP
fate.
is chosen by the banks, either banks or by the NCLT. I mean, home buyers have nothing to do.
नहीं नहीं ऐसा नहीं है sir. That is not correct understanding. That's where I am telling you. This is not a correct understanding. Even the banks get the wrong RPs appointed. In case of JSW, the banks have appointed him. So there is no. So please go back to the foundation of this law. The IBBI has said that they will only have fit and proper persons as resolution professionals, which is not the case. That's a first failure. Second, the understanding of the resolution professionals on the commercial side is good, but on the legal side is woefully short. They are just certifying every resolution plan as compliant plan without the application of mind, without the understanding of the law. They are just going by the whims and fancies of the creditors. Whatever the creditors tell, whatever the resolution applicant tells the RP is saying this is a compliant plan.
Question
That is what
marks
is
on the competence of RPs are real. Well, let us admit this.
Yes.
Okay.
In big cases.
Madam, I would just add 2 points which are very positive things. Couple of days ago, one applicant who has been successful already called me and said that I have read about this JSW judgment and we were to pay in 60 days and we are thinking about stretching it to 2 years just like that. And now it doesn't appear to be possible now. So this was a kind of strategy that was possibly in the minds of many SRAs.
That is
that
how
get
the
the plan
RPs.
approved.
Yes, that's how the
Yes, sir.
RPs are setting the expectations. The
Yes,
wrong
yes, yes. So
expectations.
yes.
This
So
is the
that is one
expectations
thing.
being set by the
Yes,
RPs.
yes.
This kind of wrong expectations I see every day.
In one matter where we are advising this. Yes, sir. Yes, sir.
It was because of some precedent.
And in another matter, the COC where we are advising, they called us to say that we have seen the JSW judgment. I, as an officer who attends the meeting, I am understanding the importance of IBC and the timelines. However, my senior management doesn't respond to me, doesn't pass resolutions quickly, etc., and there is delay on our part. So please write advice to us that unless we respond quickly, the timelines will not be met and the blame will be on the COC. So can you advise like that to us? That was what the officer who appears in the meeting asked. So they are also aware, but somehow the system is not helping them. So
No,
this will help COC's response also in a better manner.
I would argue it like this. The model timelines are very, very stringent and inflexible. That's my first argument. My second argument is that as committee of creditors, as banks, as lenders, their association should have engaged with the government, engaged with the regulator as to what is their expectations on the timelines. They would, of course, want faster admissions, but they would want more time for CIRP maybe. They would want more time for liquidation maybe. So we have to allow the law. We have oversold the timelines issue to Supreme Court, and this is the fate. So we'll have to accept the fate. This has been oversold to Supreme Court, the timelines of IBC. Thank you.
I think
I think
सर इसमें एक ये भी इशू है. I remember in 2019 and 20 when we all were very strict about following timelines, and COC also was doing that. We used to hold meetings on Saturday evening at 7 o'clock on Sunday morning also. But nowadays, COC members simply tell it's public holiday. I am not coming for the meeting. Reschedule the meeting. So their approach has been very lackluster. COC can't do anything. Everything is directive for COC. Extension ले लेंगे, एक महीना मिल जाएगा. How does it happen? How does it matter?
So the
So all
government,
this will change now.
yes.
All
So
this
the
will change
government,
now.
Yeah,
so
they
the
are,
government when instituted the timelines were hoping that we will treat the sick company like a sick person. So we will all be available 24/7. But the system has not responded to that. Thank you.
Thank you.
Very-
I think it's 6 o'clock. Unless anyone has a point or view on this case other than what is already discussed, can we close this discussion, please?
Only one thing, madam, that COC needs to be regulated either directly by IBB or through RBI.
The
I think there is no regulation at all on the COC.
IBBI has already made a, code of
They,
conduct for
they
that.
have given only code of conduct that is not working out.
Yeah.
Now there is a research proposal by IBBI. Many of you might have got invitations. One of the subject is COC and its behavior. So please contribute to it and make a good research paper.
Yeah, and they are also, the COC is also getting message through this, that how they have been also their action and inaction is taken, that we rightly mentioned. So with this, I think we will conclude this discussion. As we know that what is, the question is Supreme Court has used the Article 142 to, give this order whereby they are given the power to give any order which give complete justice, which should ensure complete justice in any pending case or matter. The question remains whether complete justice in this case or matter has been done in view of the situation which we discussed, whether the justice is got to the corporate, CD, employee, and others who are affected with this situation, how the situation will take place, whether this order could have been in a different way so that the prosperity and the future of the CD could have not hampered or not in a danger. With this, I will close this discussion and I'll pass on to ICICI. Thanks. Sorry, I forgot to ICICI.
Okay. Before we close, I have an announcement just coming in. A great news that India and Pakistan have agreed for immediate ceasefire.
Great. That
So
is
that will also add to the economy. It's economic news.
We have a good discussion on this. I don't think it is good news or great news. I have reasons for the same.
Sir, I'm Sanjay.
It's all
Paul. I
Mr.
agree with
Trump's
the gentleman.
intervention.
May I say something? I don't agree with this, that this is good news. This is a very bad news.
This is
Pakistan should be annihilated. I'm Kashmiri, so I understand much better than any other Indian what this Pakistan bastard is. So this is all nonsense. Sorry, I'm digressing. And what happened in Pahalgam? उसके बाद जो दिखाया कि जी लोगों ने मार्च पास निकाला, ये निकाला, सब बकवास है. उनको पता है उनकी रोजी रोटी इफेक्ट होगी, इसलिए उन्होंने ऐसा किया. ऐसा कुछ भी नहीं है. और वो उन्होंने खुद हेल्प, अभी तक टेररिस्ट को नहीं पकड़े गए. They are helping themselves. 99% of Muslims in Kashmir are anti-Indians.
Sanjay Saab, Sanjay Saab, I can feel your pain. I have worked in Kashmir for 14 long years in very different capacities. I know the pain of Kashmiris. I have worked on the relief camps of Kashmiris for 5-6 years as a volunteer, so I understand what goes on there. But believe me, the news is still good.
Sir, Sanjay
सर आई थिंक सर वार होना अच्छी बात नहीं है, वार का स्टॉप होना अच्छी बात है।
सर ये
Yes,
वॉर ही
that-
सोल्यूशन है।
That is the point.
वॉर शुड, चाहे इंडिया से 1 करोड़ आदमी मरे, वहां के 24 करोड़ आदमी मरने चाहिए। वॉर ही सोल्यूशन है।
Sir,
देयर इज नो अदर सोल्यूशन।
Sanjay sir,
आई मीन आई अंडरस्टैंड पीपल, यहाँ के लोग बहुत
I
पॉपुलर अपने आप
think
को
we
बोलते
are
हैं।
going on a wrong direction on this.
Dipti ji, please close the discussion. This is not the forum. Yeah, let us not take it forward.
Topic, but let us not
I will say, because peace is for everyone, every individual. I will request
yes, let us
ICICI.
not touch this topic because सबके views अपने होंगे, but let us not touch this topic at all.
Okay, I dropped the word good from my statement.
Yeah,
It's a news.
I request ICSI representative to close the session, please. And thanks ICSI IIP for giving us this platform to discuss this, all RPs, and share their views. I think.
Thank you very much, all the participants, for giving your valuable inputs on the judgment.
Thank you, madam.
Thank you.
Thank you. Thank you, everyone.
Thank you.
Thank you.
Thank you.
Sanjeev Chaudhary